For some, filing for bankruptcy will not only bring a lot of much needed relief, it's actually a smart financial step. Bankruptcy could clear away a lot of debt and truly provide a fresh start. However, there are situations where filing for bankruptcy can be a very bad idea. In this video, I'll discuss 4 scenarios where bankruptcy could end up being more trouble than it's worth. Number 1, you have unprotected assets. This applies specifically to a Chapter 7 bankruptcy. Chapter 7 filing is a relatively short process and really packs a punch in that it will eliminate almost all of your unsecured debts. Debts like medical bills, credit cards, personal loans, they'll be completely eliminated. However, a Chapter 7 is a liquidating bankruptcy, meaning if you have assets that are not protected by one of your state's exemption laws, there's a chance the bankruptcy trustee will seize the asset, sell it, and give the money to your creditors. With this in mind, if you have significant non-exempt assets, a Chapter 7 filing could end up costing you a lot in terms of lost assets. For instance, if you live in Arizona, where I practice, and you own a boat free and clear of any loan, then there's a good chance it would be seized. Same thing for ATVs, RVs, and most other big-ticket toys. Exemption laws protect most of your essentials, like household items, cars, wedding rings, retirement accounts. But if you happen to have something valuable that's not protected, you may want to reconsider your decision to file a Chapter 7 bankruptcy and possibly look to a Chapter 13 bankruptcy where you won't lose the assets, but will be required to complete a payment plan over 5 years. Second, you recently gave away assets. If you're considering filing for bankruptcy, it is best to maintain the status quo. And what I mean by that is you shouldn't be taking your name off the title on vehicles or transferring assets to another family member. This can cause big problems. In bankruptcy, there are laws that state that if you've given away an asset to someone who didn't pay you anything within 2 years prior to your bankruptcy filing, then it's considered a fraudulent transfer, whether you actually had any fraudulent intent or not. The reason these laws are in place is because they don't want people to transfer all their assets out of their name, file for bankruptcy, and then transfer everything back into their name once the bankruptcy is over. This would be unfair to your creditors. So the law allows the court to undo those transfers that occurred within 2 years prior to your bankruptcy filing, in which you gave away an asset and didn't receive anything in return. The most common scenario where I see this occur is almost always very innocent. A couple needs to file for bankruptcy, and prior to filing their bankruptcy, they transfer the title to a vehicle that their 20-something kid has been driving since they were 16 years old. Even though there's no intent to defraud your creditors, the kid ends up getting a call from the bankruptcy trustee to turn the vehicle over. If you're in a similar situation, it's best to meet with your bankruptcy lawyer before you transfer your name off of any asset. It could end up saving you and the person you transfer the asset to a lot of grief and money. Number 3, you recently paid back a lot of money to a family member or friend. Now, I understand why people do this, but it can cause problems in your bankruptcy filing. The thinking goes along these lines. I'm going to file for bankruptcy. I owe my brother $5,000, and I don't want him to think that I'm not going to pay him back. So I'm going to pay him back and then file my bankruptcy. The reason why this can be a big problem is that one of the ideas underlying the bankruptcy system is that your creditors will be treated equally, and any distribution of money will result in all of your creditors getting their fair share of the money. If you pay your brother $5,000 and pay your credit cards $0, then you're clearly preferring your brother over your other creditors, and this is known as a preference. How the rule works is if you have paid any of your run-of-the-mill creditors more than $600 in the 90 days prior to your bankruptcy filing, the bankruptcy trustee can go back and ask for that money back. Further, if you've paid any of your family members or close friends money back in the last 12 months before your bankruptcy was filed, the bankruptcy trustee can go and demand that they give that money back to the court so that it can be distributed fairly to all of your creditors. Having a bankruptcy trustee contact your brother can not only make Thanksgiving really awkward, but can be a reason not to file a Chapter 7 bankruptcy, or to at least consider postponing it until a year has passed since you paid the debt. Number 4, you have debts that you have incurred through fraud. Now, this one is rare, but if you have debts where there was fraud involved, filing bankruptcy may not be a good idea. Here's why. If a creditor believes that the debt you owe was incurred fraudulently, then they have the right to come into your bankruptcy case and file a mini lawsuit known as an adversarial proceeding to ask the court to determine if their debt was incurred through fraud. If the judge determines it was, then the specific debt will be deemed non-dischargeable, meaning that the particular debt is yours to keep for life. It will not be going away in the bankruptcy. Adversary proceedings can not only result in a debt not being discharged in your bankruptcy, but can be costly, as the legal fees for defending an adversary proceeding are usually not included in the flat rate bankruptcy fee that most attorneys charge. It's important to note that these types of proceedings are pretty rare, and the requirements to prove fraud is not easy to do. Incurring debts and then running into hard times and not paying back your debts is not fraud. However, if you're involved in a Bernie Madoff type scheme, bankruptcy is likely not a good option. If you can't file for bankruptcy, what are your options? I understand that it's all fine and good to understand that there are situations where a bankruptcy filing could cause you a lot of grief, but that doesn't help you deal with your debt problem. There are other options, including bankruptcy options, that can help you to eliminate most, if not all, of your debts. Most of the problem scenarios described in this video really are only problems in a Chapter 7 filing, with the exception of fraud, which is going to be an issue in any type of bankruptcy. Chapter 13 bankruptcy can be a viable option that will allow you to keep your assets and eliminate most of your unsecured debts. You'll have to make payments to your creditors over the next 5 years, but in the end, you'll likely be able to eliminate most of your debts. Another option is debt settlement. Debt settlement is the process where you approach your creditors and offer to pay them an amount less than what is actually owed. Debt settlement can work, but has the obvious downside that you're going to need to have a fair amount of cash to make it work. One of the most important takeaways I can give you in this video is that if you're considering bankruptcy, meet with a bankruptcy attorney early on in the decision-making process. Too often people meet with an attorney after decisions have been made that will adversely impact the bankruptcy filing. Almost all bankruptcy attorneys will meet with you at least once for free and can give you a pretty good idea of things you should and shouldn't do in leading up to your bankruptcy filing. Thanks for watching.